Well, good evening, everybody, and welcome back to AJ 101 Criminal Law Online. This is going to be your Chapter 4 lecture, and we are going to cover capacity to commit crimes and the insanity defense. And this is kind of an interesting chapter because when you look at things like the insanity defense, and you discuss issues related to law when you're talking about those who are capable or incapable of committing crimes, it makes it very interesting. You've probably watched TV dramas where you've seen defense attorneys kind of throw out different defenses for their clients and what have you. And some of some of the things you saw on TV might actually be true. Now, there's a couple of videos that I am going to post inside the content area, and the first one will be a video of the sleepwalking defense case. It's really cool to watch. I think you'll have a good time watching it. Not what happened to the person, but the defense itself. And then there's also kind of a really sad case, the Andrea Yates case, which is a purely insanity defense type case. I'd like you to view those, and this helps add context to what we're talking about. So as we get into some of these chapters, I am going to be posting videos here and there that, while they're not mandatory that you watch, honestly, you really should, because it really will help you understand better what we are speaking about. So there you go. So let's move on. So persons capable of committing crimes. Well, who are they? Well, if you look in the penal code, that big fat blue book that has the million pages of codes and things like that, if you look under Penal Code 26, you will find a list of those that are considered to be incapable, because there are some cases here. So Penal Code Section 26 states that all persons are capable of committing crimes. Okay, so that's all of us except those that are listed below in the following classes. Now, there are some criteria that fall in there as well. So you have children under 14 that meet certain rules: mental incapacity, ignorance or mistake of fact. Now, that doesn't mean ignorance of the law is an excuse, and we'll explain more about that. Unconsciousness, you're probably asking, well, how can they commit a crime if they're unconscious? Well, we'll get to that. Accident or misfortune, and threats, duress, or coercion. So let's kind of give you a little bit more to each one. So children under the age of 14, in the absence of clear proof at the time of committing the act charged, whatever it is they said they did, the act charged against them, they knew its wrongfulness. So, and we're going to talk more about juveniles as well, but they do have to know right from wrong. And again, we'll get more to that. Number two, persons who are mentally incapacitated. Number three, persons who committed the act or made the omission charged under ignorance or mistake of fact, which disproves any criminal intent. Now, is criminal intent important? You bet it is, because if you think back to a couple of chapters we talked about, crimes have intent, and some have what? Do you remember? Specific intent, general intent, and then there's that weird one that comes in at the bottom, transferred intent. So, terminology papers, the ones that I passed out to you, you should be reading those every single chapter. Number four, persons who committed the act charged without being conscious thereof. Five, persons who committed the act or made the omission charged through misfortune or by accident, when it appears that there was no evil design, intention, or culpable wrongful negligence. Okay, and six, persons, unless the crime can be punishable by death, who committed the act or made the omission charged under threats or menace or menaces, plural, sufficient to show that they had reasonable cause and did believe their lives would be endangered if they refused. So threats of duress. Could somebody actually be threatened to go out and commit a crime? Very, very possible. So these are those exceptions that we kind of talked about. Now, along with that, okay, to kind of help you get a grasp on some of these things, would be this theory of criminal responsibility. And trying to think of the easiest way to, okay, so let me explain it like this. The theory of criminal responsibility: the law itself assumes capacity upon the part of all persons except those in certain exempted classes, which we just discussed. So the law assumes that everybody, okay, is capable of committing a crime except those in the classifications that we just talked about, right? Okay, to comply with the standards of conduct set by criminal law. So we all should be able to do this with those that are in the exception area. Criminal responsibility simply means liability to legal punishment. In certain situations, the law exempts persons from criminal responsibility who are not entirely blameless, but who by reason of circumstances, maybe even beyond their control, are not sufficiently blameworthy to be punished, and that does happen. So we'll kind of get into a little bit more about that as we kind of dive into this chapter a little bit further. So we what we've been talking about for the most part is kind of adults with a little bit of kid stuff in there. But now let's look at children under the age of 14. Well, what about these young kids that commit these crimes? And how do they fit in, and how do we deal with that? A plug for my juvenile law or juvenile procedure class. Great class. Come take it. Take it with me. You'll learn a lot, and you would probably already know what we're going to talk about right now. But if you don't, that's okay, because that's why you're in this class. So children under the age of 14. So how do we kind of deal with that? Well, the common law rule regarding the criminal responsibility of children and the fact they are conclusively presumed to be mentally incapable of committing any crime is completely non-existent in California. Okay, the age referred to in the California statute under 14 years refers to chronological and not mental age. So at common law, children were presumed mentally incapable to commit crimes. Well, California statutory law under 14 refers to chronological age, not mental age. All persons under 18 years of age are subject to the juvenile court. We'll talk a little more about that in a minute. And persons under 18 are still afforded similar constitutional rights as adults, with a very important case law at the bottom that I would suggest you look up, in re Galt. And we'll talk about that Galt case in a few more. So kind of a little review now. All persons in the state who are under 18 years of age are subject to the provisions of the juvenile court law specifically and penal law generally. The primary jurisdiction for criminal cases involving persons under the age of 18 years rests entirely with the juvenile court. It is also highly unlikely that a juvenile under the age of even 16 who has committed a crime less than a felony would ever be subject to the formal adversarial judicial proceeding, which are reserved strictly for adults, but it does happen. So it's not to say that children under 18 are not given rights equal to adults. Really, on the contrary, the Supreme Court, particularly in that case that I just talked about, that In re Galt case, spells out the fact that juveniles are to have many of the same inherent constitutional rights as those older than them, their elders, if you will. But juveniles have no right to bail or no right to a jury trial. And again, if you were in my juvenile procedure class, you would be well aware of that. So we'll move on. Also, as we kind of talk through this a little bit more, juveniles are, it's kind of unique, the juvenile justice system. So juveniles are not considered to have committed crimes, but rather have a unique status of criminality, which is called juvenile delinquency. So we don't say they committed a crime, they committed a delinquent act, and what have you. And as I previously mentioned, the juvenile court has primary jurisdiction in the state in cases involving youthful offenders under 18 years of age. The juvenile court may, however, as a discretionary matter, find a juvenile unfit for juvenile court in the case of any juvenile who is at least 16 years of age, 14 in some cases, but typically 16, and who committed what would have amounted to a serious felony had the same offense been committed by an adult. Thus, it can really be seen that the provision of Penal Code 26.1 relating to children under 14 years is more applicable to the juvenile court proceedings than to the adult criminal court process. I know that's a lot of legalese to kind of shove in there out of my brain into your brain, but there you have it. So when we talk about that capacity to commit crime still, because we're kind of there and we're talking about kids under 14. So the question of the capacity of a minor under 14 to commit a crime was the subject of a California Supreme Court case called In Re Gladys R. And that's on the slide that you're looking at right now. And that's another really important case because the accused here must have known the wrongfulness of the act at the time the act was committed. Okay, so to hold a minor under 14 culpable to commit a crime, the law requires the state to prove what I just said, that the accused have known the wrongfulness of the act at the time the act was committed. Now, there are other areas that can fall into place to help you prove that, which are some that are listed here. So you have like age, intelligence, education, experience, but a little more on this Gladys R case because it's kind of an interesting one. So 12-year-old Gladys had been charged in a juvenile court petition with violating Penal Code Section 647A, child annoyance. The juvenile court judge had sustained the petition after the hearing, but no showing had been made that the young lady, Gladys, understood the wrongfulness of her act at the time she committed it. So on appeal, the Supreme Court reversed the wardship in this case, finding and held that whenever a juvenile court conducts a 602 hearing, which is a criminal hearing for kids, if you will, involving conduct by a minor under 14 years of age, the court should require evidence, okay, that the minor had an appreciation or understanding of the wrongfulness of her conduct at the time the offense was committed. That should make sense. The decision suggests that more extensive questioning should have created a stronger court case. It also points out, kind of what you're going to see on the bottom part of the slide here, that minors under 14, clear proof must be shown at the time of the offense. The youngster knew the wrongfulness of the act. And areas that you can look at, other relevant areas of inquiry would include age, intelligence, education, experience, maybe even prior police contacts. In addition, you can, you could question the minor's parents, teachers, friends. That would also help you possibly produce evidence helpful in proving that the minor understood the difference between right and wrong, etc. So that's kind of how we deal with juveniles when it talks about capacity to commit crimes. Now, there's a lot more, but this is just, again, we're kind of brushing the surface. But it should give you a good picture of what I'm talking about. So now we're going to kind of move on to mental incapacity and what does that really mean and how does that all fit in. And again, don't forget to watch the 2 videos that I post. I think you'll find them very, very intriguing. So persons who are mentally incapacitated are exempt by law from criminal culpability. And you're probably asking yourself, well, why is that if they go out and commit a crime? Well, these individuals who are without mental mentality or without understanding. So you have to kind of weigh that. And so let me give you kind of a definition. Maybe this will help you a little bit as well. So a person who is mentally incapacitated is defined as one who is virtually without mentality. Okay, an easier thing to understand would be one who is without understanding. Now this defense, okay, it's clearly separated from that of an insanity plea and represents the defendant's mental status from birth. So we're not saying, hey, I snapped, I went crazy because of this, and I was insane, or, at the time that I did this, I was out of my mind. No, we're saying mental capacity from birth, that person's overall mental capacity. Does that make sense? So don't get the fact that somebody is mentally incapacitated confused with somebody that's using the defense of, hey, I'm crazy. Or something like that, and hopefully that does make sense. Now there's a So such a person is said to be incapable of appreciating, understanding, okay, the character and significance of their acts. Now, the mentally incapacitated as characterized by the Stanford Binet Intelligence Scales testing possesses a score of between 10 and 24, and we're not going to spend a lot of time on that. I just want you to know that there's a test for this. So it's not like they can just say, hey, I have this issue, therefore I'm not responsible. There is an IQ test for things like that, and the courts will have experts provide this test and do this test to the individual and be able to testify in court, and so on. Now, also, finally, to kind of wrap this part up, don't confuse mental retardation with mental incapacity just on its face. Mental retardation does not generally fall into this area unless, however, it can be shown that the defendant is incapable of knowing the wrongfulness of their act. And that would be, again, it would have to be cleared up in court. So if you go back a couple of slides, and we're not going to go back, we listed some of these areas, okay? When we looked at Penal Code 26, we talked about kids under 14, so we've kind of gone through that. We talked about those that might be mentally incapacitated. And now we're going to kind of move into that area of ignorance or mistake of fact, because people are probably going, well, God, what? So I just made a mistake, so no one's responsible for it? Or how does that all kind of fit in there? So let's discuss that a little bit. So someone who honestly and mistakenly commits or omits an act which would ordinarily result in a crime, were it not for the lack of criminal intent, may usually introduce the defense, okay, this particular defense, which would be ignorance or mistake of fact. So part of the pieces here is in the middle of the sentence there in parentheses that you can see. So one who honestly and mistakenly commits or omits an act lacking mens rea, okay, so intent, may introduce ignorance as a defense. Okay, and remember, these aren't just like all these things we're talking about. They're not automatic. These are defenses, okay? The mistake must be of fact, not of law. All right? Ignorance of the law is generally not a criminal defense, okay? The fact that I didn't know that there was a law against killing somebody doesn't mean it's going to get me out of the prosecution of that. Okay, mistake of fact lacks criminal intent. Now, there's a very, very interesting story here that I probably won't take too much time to go over, but you can review this mistake of fact defense of Dr. Samuel Mudd, who was tried for aiding John Wilkes Booth after Booth's assassination of President Abraham Lincoln. And, you know, kind of in a nutshell, basically the assassination takes place, and Booth ends up going to Dr. Mudd and asking for shelter and even money and things like that. But Dr. Mudd didn't know what Booth had done. And again, this was a very short version of this whole thing, and kind of gave him a place to stay and then let him leave the next day, etc. And later on, Dr. Mudd was arrested for basically helping, harboring, and assisting Mr. Booth. But again, Mr. Mudd did not know what had taken place. Okay, so that was the short little part of it. There's a heck of a lot more to it, so I would suggest that you really kind of read the story. But this is it's a good example of this mistake of fact or ignorant type thing. Unconsciousness of fact. Well, let me back up a little bit to ignorance of the law. So we talked about ignorance or mistake of fact. Ignorance of the law, we know, while ignorance of the law is no defense to a criminal prosecution, a A penalty, if you will, may be avoided upon proof of ignorance or mistake. However, where one does an unlawful act voluntarily and willfully, he is presumed, he or she, to have intended what that person did, as well as all natural, probable, and usual consequences of such an act. Okay, so one cannot claim a defense of mistake of fact where his immediate act constitutes the requisites of a crime. So, thus, setting fire to a home to defraud the insurer, wherein a homicide is committed inadvertently, okay, is nonetheless murder. So basically, if you meant to burn the house down to collect the insurance money, but you killed someone in the process, you can't claim the defense of mistake of fact, okay, because there are going to be consequences. Things happen. If that kind of example makes sense to all of you. So unconsciousness of fact relates to the lack of functioning of the unconsciousness of the mind. Has no reference to insanity or mental disease. So an example could be the video that I'm going to show you: sleepwalking, fever, delirium, a blow to the head, involuntary intoxication. Okay, involuntary, there's a difference between voluntary and involuntary. So you could claim the defense of sleepwalking, and while you were sleepwalking, something happened. Sometimes those that are struck on the head might attack people because they don't really know what's going on because of the damage to their brain or to their head. So this is this unconsciousness of act type situation. So this, hopefully that kind of clears it up. The burden of proof here is on the defendant to prove the unconscious state, not the prosecutor. And again, voluntary intoxication is not a defense when the crime is a general intent crime. But if somebody slipped something into your drink and you didn't know about it and it was involuntary and you did something, that could be easily a defense to whatever it is that you might have been accused of. So hopefully that kind of gets that going a little bit. So kind of a quick review so you kind of get this unconsciousness of act thing. One may present a defense to his or her acts under the provision of Penal Code 26, paragraph 4, where he or she can show that such acts were not voluntarily done by him, but were caused by an irrational response, if you will, of which he or she was unconscious. Such a defense has no reference to insanity or mental disease, which we kind of talked about. So examples are, again, I kind of said that, performing acts while asleep or suffering from delirium, blow to the head, taking drugs involuntarily, things like that. And we talked about burden of proof and everything else. So I think we kind of got this one nailed, and we can move on. Accident or misfortune. So can things just be an accident? Well, yeah, they sort of can. A defense under Penal Code 26, paragraph 5 is based upon the absolute lack of the requisites of a crime or a lack of criminal act, intent, negligence, or evil design on the part of the defendant. So a lack of all of those. Such a defense is often offered in cases of homicide, either excusable or justifiable. So an example would be, what's a good example I can give you? If a person were to drive a car within the speed limit and a child runs into the path of the car in pursuit of, like, a ball, they kick a soccer ball in the street, the death of such child would have been unintentional, with no evil design on the part of the driver, assuming that the vehicle was operationally sound and there was no negligence, blah, blah, blah. Does that make sense? It's an accident. It's a very unfortunate accident. However, in that same case, let's just throw in a little bit of a curveball here. If the driver was traveling at a high rate of speed and driving really recklessly or under the influence of alcohol or drugs, such a defense couldn't be used, right? Because those other pieces in there that I talked about. Lack of criminal act, intent, negligence, or evil design. Okay, now some of those are there. So you can't use this, you wouldn't be able to use it as a defense. So hopefully that kind of clears that up for you. So this defense is based on the absolute lack of intent, evil design on the part of the defendant. Such a defense is often offered in cases of bodily injury or homicide cases. We kind of went over that. The killing of a human being is excusable when doing an act by lawful means without unlawful intent. Okay, Penal Code 195. So I'll have you kind of look that up as well. So let me see if I can give you any more examples in my brain here. The majority of cases in which accident and misfortune have been used as a defense, again, generally have to do with bodily injury or homicide cases. So let's see. Examples would include the first one, lawfully correcting a child who, following a mild swat, ran from the parent and was fatally injured falling down the stairs. I know that seems kind of like way out there, but that could be one. Another one, in defending oneself from an unprovoked attack, where a single blow to an assailant's chin caused him to fall back against a sharp object, which caused his death. So, I mean, that would fall into some of those categories. So I won't confuse you too much further on that one. So the next one, threats, duress, coercion. Penal Code 26, Section 6 allows the accused to use the defense of threats, duress, or coercion if they had reason to believe their life was endangered. Now, this defense may not be used if the crime is punishable by death. The social policy is that you may not take a life to save your own life. The exception, of course, is self-defense. Now, if you look at that really super famous case of Patty Hearst, that wealthy heiress, if you remember who she was kidnapped and then became an aider to the group's criminal activity. So the question always comes down to whether was she threatened or brainwashed or whatever. On that. So kind of in review, when a person is forced to commit a crime because of threats or menace sufficient to show that that person had reasonable cause to and believed that their life would be endangered, if they refused, they may be able to use this particular defense. Okay, so thus, where one forces another to rob a liquor store with an unloaded gun by threatening to shoot the perpetrator if he fails to comply, the innocent perpetrator who committed the crime under threat of certain death would not be responsible for the commission of such crime. Make sense? Threats of future danger of loss of life is no defense. The danger has to be real and immediate. Okay, so on the other hand, though, I'll give you another example. If A threatens to kill B, if the latter fails to commit homicide upon C, this defense is not applicable, okay? Because remember, we talked about that the death penalty cases, okay? In the commission of any crime, evidence as to whether a person was coerced and forced to assist the perpetrator due to fear for coercion is a question of fact for the jury to resolve. So the jury is going to have to kind of figure that one out. So hopefully that kind of clears up the threats, duress, and coercion. But keep in mind, it needs to be kind of an immediate thing. So what about this insanity thing? Okay, can people really claim that they're crazy? Well, yeah, they can. So the purpose of a legal test for insanity is to identify those people who, owing to mental illness, should not be held criminally responsible and so punished for their crime. So the question is then, what constitutes insanity? So kind of an interesting question. Well, if you look at the definition of insanity under Proposition 8, the test for legal insanity is now whether a criminal defendant proves by the preponderance of evidence or greater weight or majority that he or she was incapable of one, knowing or understanding the nature and quality of his or her act, and two, of distinguishing right from wrong at the time of the commission of the offense. So the purpose is to identify who should not be held criminally liable due to mental disease or disorder, and it must be proved by preponderance of the evidence that the defendant was incapable of understanding the nature quality of the act and distinguishing right from wrong at the time of the act. Now, the McNaughton test is used in California and is one of those tests that helps the courts determine someone's sanity. So the McNaughton test, essentially, Proposition 8 kind of reinstated the traditional McNaughton rule on insanity, often referred to, you might have heard of it as like the right and wrong test. The McNaughton rule was in effect since it was first adopted by the California Supreme Court way back in 1864, super old, until overturned by the California Supreme Court in 1978 in a case called People versus Drew. The McNaughton test now for insanity in California now requires the defendant to clearly prove by a preponderance of evidence that at the time of committing the act, the defendant was laboring under such defect of reason as not to know the nature and quality of his or her actions. And second, if the defendant did know it, that he or she did not know that what they were doing was wrong. And in essence, this is the McNaughton right-wrong rule. Now, the burden of proof here, insanity is a defense to a crime. The law presumes that every person is sane and free from mental illness. So this means that the burden of proof is going to be on the defendant, because the law says that basically everybody is sane unless proven otherwise. Okay, so the accused person must prove by a preponderance of the evidence that he or she was incapable of knowing or understanding the nature and quality of their actions and of distinguishing right from wrong at the time of the commission of the offense. Okay, does that kind of make sense? Now, there's also something that we're going to kind of get into that's called temporary insanity, and so hold off on this one slide right here because I just kind of thought about that right now. So temporary insanity, basically, so legal insanity of a short duration. Okay, so that's kind of like the legal part. If existing at the time of the commission of the offense, is fully recognized as a defense, as is that of insanity for a longer duration. For drug intoxication to be legal insanity, however, it must be what they call settled insanity and not merely a temporary mental condition produced by the recent use of intoxicants. A defense of insanity cannot be based solely on a personality or adjustment disorder, seizure disorder, or addiction to an abuse of intoxicants or whatever. So just all you kind of need to know is that there is a defense of temporary insanity. So it's legal insanity of kind of a shorter duration. Now, back to the slide here, other criminal defenses that you can kind of, that'll be out there. So other defenses to criminal prosecution can be found in other statutory and procedural parts of California law, including self-defense, entrapment. We'll talk more about entrapment later. Necessity, lawful capacity of office, and legal duty. So think about some of these, and we'll go over them a little bit later. But self-defense is pretty self-explanatory, right? Entrapment, so is a criminal defense where you've been enticed to commit some type of crime, possibly by law enforcement, and where you normally wouldn't have committed it. Necessity, That's pretty self-explanatory. Lawful capacity of office, so, or legal duty. So maybe you're in the military or you're a law enforcement officer and you have to take someone's life, or you're working undercover and you have to um, maybe commit a crime so you're not discovered. I'm just saying that these are things that are there. So these are criminal defenses that are out there for you to kind of consider, and they are found in procedural parts of California law. So that pretty much wraps up Chapter 4. Capacity to commit crimes and the insanity defense. Again, don't forget to view those 2 videos that I posted, because they will really help you add some context to this whole insanity type defense, and the law and how it works. So with that being said, that's all for Chapter 4. If you have any questions, please, again, post them on the discussion board, and I will look forward to talking to you next week. So more to come.